Member Tina Sovkina.
Благодарю, председатель.
Thank you, Chair. The question of the protection of the rights of indigenous peoples and legal systems is an important multi-layered issue. It includes legal, social, cultural aspects. I would like to speak about the Russian Federation for a little bit, and I'd like to show how, as of today, the entire system for protecting the rights of small number indigenous peoples works. We have a constitution, the Constitution of the Russian Federation. Its Article 69 talks about and guarantees the rights of indigenous peoples. Federal Law number 82, guaranteeing the rights of small-numbered indigenous peoples, exists as well. We also have legislative acts of the subjects, the constituent entities of the Russian Federation, where small-numbered indigenous peoples live. In that case, representatives of small-numbered indigenous peoples have the right to legal assistance free of charge, especially if they live below the poverty line. The poverty line in Russia is 17,000 rubles. It's clear that people can apply for assistance, and practice has shown that such assistance is not always positive. Practically all of the cases are not won. The Russian Federation has signed but not ratified the Convention of the ILO, Rule 69, but I'd like to note that the lack of effective access to justice is present. Many small-numbered indigenous peoples live in remote areas with no lawyers or internet or courts. Some representatives of small-numbered indigenous peoples don't have a mastery of the Russian language that would be sufficient to champion their rights in the court. There's also legal illiteracy. For example, there are cases in which people weren't able to show that they were correct simply because people didn't understand what they were being asked. And there's no training of attorneys that are specialized in the rights of small-numbered indigenous persons, especially in areas where not very many of them live. Specifically, our rights are infringed on due to the raw materials, natural resources on our land. The weight here is on business and on the state. There are many such cases. I would like to mention a large-scale case, the case of Sergei Kichinyov, who unfortunately has now departed to the land of his ancestors. So, when cases oppose indigenous peoples and the business community, often the courts are not independent. What can be proposed here? Number one, creating an institute of attorneys to protect the interests of small-numbered indigenous peoples, where there can be training of attorneys that specialize in the rights of indigenous peoples. It would be preferable, of course, for indigenous peoples themselves to be those attorneys. Also, we need to create a database. Next, we need to have interpreters and cultural mediators in legal contexts. Third, a group of legal support in universities that can work with cases of indigenous peoples in cooperation with human rights NGOs. Fourth recommendation, independent monitoring and statistics on court cases with collection and publication of data on the court cases with participation of small-numbered indigenous peoples. It would be preferable to have that be anonymous. And five, ratification of the ILO Convention 169 that would have a legally binding status for small number of indigenous peoples. Thank you.